Hi, everyone. This is attorney Angie Holloway. I am the managing partner of Edmonds Law Office, and I'm known as the lawyer for doctors. And this quick 10-minute video, we are going to talk about scaling your medical practice in Georgia and everything that you need to know to avoid lawsuits, fines, and penalties. All right, so let's get into it. What are we talking about today? We're going to talk about first, complex compliance and employment, patient contracts, and minimizing your liability for your medical practice. Second, we're going to talk about some common mistakes with some examples, ignoring compliance, weak contracts, and how lack of strategic planning can lead to disaster in your medical practice. And lastly, if after watching this video, you're a little bit confused and wondering whether or not your patient contract is up to standards, you can download our free patient contract audit today and in less than 10 minutes, find out where you stand. All right, for those of you that do not know me, my name is Angie, aka Ask Angie, and I am the lawyer for doctors. I help Georgia medical practices protect their licenses, their practices, and their peace with concierge legal services. A little bit about my background is I've been practicing law for over 8 years. I've represented individuals and businesses in various lawsuits in state and federal courts. And now at this juncture of my practice, I devote all of my time to helping medical practice owners avoid lawsuits and chaos with proactive legal strategies. Okay, so let's get into it. How can you avoid fines, penalties, and lawsuits in your Georgia medical practice? All right, number one, we're going to talk about compliance. So we have federal compliance, state compliance, and regulatory compliance. Number two, we're going to talk about some employment mistakes that I see often. And number three, we're going to talk about that standard contract that you might be using as a patient contract that has a lot of loopholes in it that could be creating risks in your business that you're not aware of. All right, so in order for us to talk about compliance, we need to kind of get a good understanding of what the actual compliance regime that we're under. So of course we have federal. These are some of the few federal laws that apply to most medical practices. Of course you have HIPAA, which is patient safety and protecting their patient data. You have the Stark law, which is a law that regulates whether or not you can refer, physicians can get actual revenue and income under the Stark law. And the FTC Act is related to false advertising. And so one of the things that I see, especially as medical practice owners are trying to scale, is that the common mistake is to go to the HIPAA government site, download that template, and just automatically start using it in your practice. That by in and of itself is not enough to protect your business or your medical practice from liability. So you need to have an actual HIPAA compliance regime and protocol, which would include like a procedure for responding to requests for confidential and protected data. It would include you having a designated individual in your practice who's going to serve as that compliance officer who may do monthly or quarterly audits to make sure that you guys are following all the necessary procedures in your medical practice. And another step that you need is, okay, so in addition to having a compliance officer and procedures that you're going to be following, you're also going to have some kind of training regime. So when you're bringing on new staff, whether that be a medical assistant or some type of support staff, secretary, or anything of that nature, everyone needs to be familiar with the processes and the ways in which we communicate. For example, sending emails related to any type of patient data is not a secure form of communication. Unless you have an encrypted email server that is HIPAA compliant, you should not be communicating with clients via email. Everything should be occurring in your HIPAA EHR or your compliance portal that you communicate with all of your patients on. All right, so FTC, a little bit about this. So the reason why this is something that is really important and should be on your radar as a Georgia medical practice owner is that the FTC is increasingly cracking down on medical practice owners with respect to advertising. So in 2023, the FTC sued a Dr. Akori, and sued them for basically making false claims about treating addiction, cancer, and other serious conditions. And ultimately, the doctor was required to pay a $100,000 civil penalty, and there was a permanent ban on making those types of false claims. That happened just in 2023. Last year in 2024, the FTC won a case against a stem cell institute for making false claims about stem cell therapy. And they had to also cease and desist from making future fraudulent claims. So, this is something to be cognizant of, particularly in your advertising. If you are selling products, especially related to weight loss or anything like that, to consider speaking with counsel to make sure that any types of disclaimers and that you're not putting information out there that's not supported by data that you can show. All right, so let's talk a little bit about contracts, guys. So there's a lot of different contracts that you're going to have in your practice. One of the complexities about having a medical practice is that you have all these additional oversights as far as in federal and state regulations that you have to comply with, but you also have the same obligations as any other business owner. So it's kind of like a layered effect of compliance that you have to make sure you're doing. So with contracts, you have your patient contracts, you have vendor contracts, payer contracts, lease contracts, employment contracts, and manuals. So I want to talk a little bit about each of these before we get into the patient contract, which is kind of your fundamental and foundational contract that you need in your practice. So your vendor contracts, that might be different organizations where you're receiving your medical equipment from, medical supplies. Payer contracts are those that you, if you're an insurance provider, meaning you're accepting insurance from one of these different so a payer contract is one where you are basically having a middle person, usually an insurance agency like United Healthcare or Blue Cross Blue Shield, and you negotiate those such that you can try to minimize some of the red tape and back and forth. Now, some of it cannot be avoided because of the um, just issues with the overall insurance agency. But when you are accepting insurance, that is something that can be negotiated. For example, things like the right for the payer to deny your claim after pre-approval, right? So different nuances like that in order to try to prevent kind of these attenuated and extended processes for actually getting paid, even if that is a nominal amount, right? So lease contracts, of course, if you're leasing a space, obviously before you get your DEA license, you need to have that physical space where you're going to be providing those medical services. And so lease contracts, some of the things that are important for you to think about are the flexibility that you need, right? A lot of times these commercial leases require a lengthy term. And so you want to think about what are your termination options, right? If you're investing a whole bunch of money, if you're investing a lot of money into building out a space, then you want to think about whether or not it would make sense for the landlord to have the right to terminate with a 60-day or a 90-day notice, which is pretty common, particularly in a competitive market in the Atlanta metro region. With employment contracts, so one of the things that I see with respect to scaling a medical practice is maybe you're just using a template that you found online, or maybe you're using a low-cost provider like LegalZoom. But the problems with those different services is that they don't have up-to-date information with respect to Georgia law. So some of the things that are implicated for employment contracts are non-compete clauses, right? And so in 2024, there's a switch in Georgia law with respect to enforcing non-competes against medical doctors in the state. Now, there are exceptions with respect to purchasing a practice and a few other things, but some of the things you want to think about is your kind of restrictive covenants, which refers to non-competes, non-solicitation clauses, and things of that nature. And when you're thinking about those particular clauses, the ones that you're going to find online are not going to be up to date. And so what good is having a particular provision that you can't even enforce, right? Non-compete clauses require a nuanced analysis to see, okay, what is that individual's role in the business? What is their role with respect to sales? Are they a key employee? And then also, what's the scope of your non-compete provision? And so there's a lot of things that need to go into being assessed prior to just copy and pasting some kind of template for those provisions. And employment manuals are really incredibly important for medical practice providers because first, it's a place for you to put your HIPAA compliance protocols and for everyone to be able to reference it. But it also provides you with a lot of protection with respect to wrongful termination lawsuits. And so one of the defenses that is available to employers is that if you have an anti-discrimination policy and it meets certain legal requirements, then one of your options, if you are sued and one of your employees alleges wrongful termination, they have to at least take advantage of whatever protocols you have in place first before they're able to move forward with that suit. And of course, there are always exceptions. I wouldn't be a good lawyer if I didn't tell you that. But those are some different compliance things that kind of interact with one another to create this risk mitigation for your practice so that you're not worried about some kind of random lawsuit or fine or audit, and you're in a place where you can respond to those things with confidence. All right, so I want to talk last about this patient contract, right? So this is kind of one of the first contracts that you should invest in when you are scaling your medical practice. A lot of times I see a simple template where it's like, a promise to pay, and these are our hours of operation, and it's a HIPAA form, right? And so that form, those specific nuances in and of themselves are not sufficient to protect your practice. You need to think about, okay, what happens, when a patient wants to file a complaint, right? What is your grievance procedure? What happens if you're doing a direct pay practice? What are your procedures if someone paid for a full year and then they want to terminate services, right? There are all these different nuances that are required for you to have some level of investment and expertise and be able to identify what those issues are before they become big, huge problems, right? And so on the right side of this page, you'll see that there is a kind of just excerpt from a case from last year where a medical malpractice plaintiff was able to get $47 million in Union County, Georgia. And so I just put that there as a reference point because obviously the worst and the highest risk to any medical practice owner is losing your license, right? And then the secondary would be to lose your practice via one of these huge lawsuits. All right, so what can we do to help? How do I help medical practice owners in Georgia? We create a custom strategy to address your top risks to protect your license and your practice. But like I said, the first thing that I usually encourage my clients to invest in is that patient agreement. So after talking through all of these things, if you're thinking about maybe you have a whole bunch of gray areas that you don't have clauses for, or you're wondering whether or not that indemnification clause is enforceable, what I would encourage you to do at this point is to download our free Audit Your Patient Contract checklist. This is a free, you can click that link right below this video and you can download it. It has within it the top 10 must-have clauses that you should have in your patient agreement. And once you look at that, you can take a few minutes and see, oh, wow, I'm missing 4 or 5 or 6 of these. And you can figure out in less than 10 minutes whether or not it would be worth your time and investment to consult with a lawyer. Thank you so much for taking the time to watch this video. Again, my name is Angie Holloway. I am the lawyer for doctors. Look forward to speaking with you guys soon. Bye-bye.